You're welcome back. This Newsfile is your most authoritative news analysis show and is brought to you by Bank of Africa's close as a partner, strong as a group and close as a partner. MTN, welcome to the new world. Star Assurance, they've been creating smiles since 1985 and celebrating 30 years of solid partnership. Now, this morning, very quickly, what's my take? My take is on the question of whether or not our narcotic laws are useful. And I'll tell you why, whether the narcotic laws are useful. Are they helping us in any way? There's a story of a mother of 9 who's been jailed 11 years for selling Indian hemp. Now, the story as reported by the Daily Graphic on Thursday was this. A mother of 9 and drinking bar operator on Wednesday broke down in tears when the Accra Circuit Court sentenced her to 11 years with hard labor for selling alcohol mixed with Indian hemp to the public. Amma Forsing, who stood quietly in the dock while her sentence was being read, started crying uncontrollably. Immediately, the judge, Mr. Abuaji Tando, pronounced the number of years she was to spend in incarceration. Her tears were such that a police officer on duty in the courtroom had to tell her to control herself because she was disturbing the court. The convict was charged with unlawfully possessing narcotic drugs. She pleaded not guilty to the charge and in her defense denied having knowledge of the drugs. The court, however, in its sentence said the convict, apart from having custody of the drugs, knew the drugs were Indian hemp. And this is what the judge said, quote, I have examined the evidence and have concluded that the drugs found on the accused person's premises indeed belong to her. She cannot therefore deny knowledge of it, unquote. The judge said, facts, just briefly, the facts of the case were that on September 29, 2015, the New Wager police arrested the convict in a soup at Botiano in the Ghana Central Municipality. The police, during their search on her premises, retrieved quantities of dried leaves suspected to be Indian hemp from her black lady's handbag. The search also revealed a wine bottle containing dried leaves suspected to be Indian hemp. Now, she's been given 11 years. A mother of 9. How useful are our narcotic laws? And the question I'm asking really is not to sort of fault the judge so much, because the law says that for possession, this is how much you go in for. Minimum, you go in for 10 years. Minimum, you go in for 10 years. And the judge used his discretion to add 1 more year to her. Somehow, if you are using it, sniffing it, or whatever, the minimum you can go in for is 5 years. If you are using it in that manner, you can go in for 5 years. But even if you're using it in that manner, as in smoking or whatever it is, there is a certain, also there's a certain space for you to even get a lesser sentence than 5 years. You could get some small fine in addition to the lesser sentence. What it means is that you could actually get just a day in jail and then you get a fine to pay. I'm sure you remember what happened to Kwalkesi. So the question really is this a very useful law? Should it remain what it is? This mother of 9 years, this mother of 9, if she has no one to help with the children, what becomes of the children? And that is how I felt very heartbroken when I read the story. So this morning, my call is to all of the stakeholders, particularly the Narcotics Control Board, to pursue more vigorously its attempts to have the law reviewed. In fact, you could go in for life for even using it. You could go in for life if you are found to have been involved in it, before. You have been convicted before. You could go in for life just for that. Does this woman actually need 11 years in jail or more to change her ways if she in fact knew that this was really marijuana, as it were, Indian hemp, and was using it in the manner that the court found. But the defense of what we normally know as the state versus Nyaminiba didn't go to her rescue. In that defense was simply that a group of people were using it, and when they went to court, they pleaded that they didn't know the fact that it was actually Indian hemp. And the court said, ignorance of the law is no excuse, but ignorance of the facts can let you go. So they were not convicted because they were a religious group and they were actually using it as a drug for medicinal purposes without knowing it was Indian hemp. I think we ought to look at this law once again. Does this mother of 9 need 10 years or more in jail to change her ways? That is, if she is indeed guilty. And that's my take this morning. Thank you very much. My guests are all seated now, so let's get into the issues that we have to discuss this morning. And my guest from my extreme right, Abdul Malik Kweku Bako. He's a regular panelist and editor-in-chief of the New Crusading Guide newspaper. Next to him is Yao Pong. He is a legal practitioner and teaches law at the Central University College. Also, my extreme left is Samuel Achia. He's lawyer and MP, Achim Ebuakwa South. And then, just by me, is James Agalga. He's Deputy Interior Minister. Of course, he's also a lawyer. We will be speaking to a few other people on the phone on the matters that we have to discuss this morning. Gentlemen, good morning and welcome to the show.
Thank you. Yes, good morning.
And I'm particularly excited that Mr. Atani has been able to join us today.
Thank you very
We've
much.
been trying to get him into the studio in the last how many weeks. Thank you very much for making time.
It's my pleasure.
Great. Now, in the order in which I introduce the issues, we will deal with them in that regard. I think that there may not be too much to say about the South African 3 and the matters arising from that. As far as McDermott's extradition is also concerned, it looks like a word or two in passing might also conclude on that matter. And then we'll deal with the STL matter that follows. And then go to look at the Economic Intelligence Unit's prediction that Nana will become president this year. And after that, we'll look at Dr. Wampa bowing out and who is likely to come in next. So I think I'd like to start with Mr. Atacha. You have been representing the 3 and you've expressed disappointment, disgust at the manner in which government or the Interior Ministry, particularly the BNI, has had to deal with your clients. First, tell us why you think that the statement that was issued by the Interior Minister was dubious. And we'll go into portions of that statement because it is important. A statement issued by the Interior Minister, a statement issued by the Ghana Immigration Service, and then after the Interior Minister, there was one issued by Nana Asante Bediachu, who you are with in this legal battle.
You see, I think the Interior Minister should have paid regard to the charges and the facts as presented. And if you look at the false declaration dimension, it becomes very obvious that these individuals have violated the immigration laws of Ghana. And therefore, I find it a bit weird that the Interior Minister who has said that there was the necessity to keep these 3 guys for the Immigration Service to deal with the matters after the bail. I think that statement was a bit unfortunate, and I'm not very sure that he had come to terms with all that was happening, because I can tell you on authority that immediately these people were kept by BNI, after they've defied the express orders of the court that they should hand over these 3 individuals to the registrar of the circuit court, they were whisked away to the BNI cells. And I can say, being counsel and having interacted with one of the gentlemen, Chris, through a phone conversation, that indeed and in fact, none of the officers of immigration service conferred with them.
Okay.
That is pretty serious.
What you're trying to explain here is that after they were taken to court on Thursday.
That is so.
And that's last week, Thursday, they were taken to court and the court granted bail.
That is
after
so.
the court granted bail, we understand that instead of going to verify the residence of the sureties and release them according to the court's orders, they did not, but they held them. The Interior Minister's statement was to the effect that they actually did not disobey the court, but it was the case that the Ghana Immigration Service had need of these people, and so requested the BNI to hold them for the Ghana Immigration Service.
Yes.
And that they went on further to do some interrogation. You are saying that cannot be true.
It's not true. They never dealt with them. There is not one single officer from the Immigration Service who interacted with the accused persons. And even if there was a necessity for any interrogation, they have the right to counsel. So there was no lawyer even present. So the statement that let us defy the order of the court for the sake of immigration, with all due respect, is not true. I mean, there was no interaction whatsoever. With immigration, and right after they've defied the orders of the court and kept them that long, they just said, "Can we go and see someone outside BNI?" And that was straight to the airport, and they were sent away, repatriated. That is what happened. So I'm tempted to believe that I have due respect for the Interior Minister, but what he put out there is not the truth.
The Interior Ministry statement in paragraph 12 said that the Ghana Immigration Service started an investigation into the immigration status of the 3 accused persons and requested the BNI to hand them over for further action. They were therefore released on the 24th of March to the Ghana Immigration Service as requested. Meanwhile, in line with regular practice, the GSI, that's the Immigration Service, requested that the BNI provide custody of the suspect. 13, during the course of the investigations, the following places were searched, and then they talked about all the places that they had to go to. You say that is not true.
It's not true.
They did not need them after the court.
At all.
And again, that in fact, after they were taken and kept unlawfully, so to speak, after the court had granted bail, the BNI, the immigration never had any contact with them.
At all. And what is even more serious is that all issues bordering on immigration had been captured in the charge sheet. You see, the issue of the false declaration, I'm tempted to surmise, were fed by the views of the immigration. Now, after they've done their background work, these individuals have violated the Immigration Act. If not, why put together such a charge?
There were 3 charges in respect of false declaration. The first charge was conspiracy, and the second charge was unlawful training in terms of military training.
So therefore, when the investigations have been completed and the people have actually been charged, there will be absolutely no necessity to come out with this story that they needed them, and as a result of that, they have to be repatriated. Maybe
let's do it this way. The Deputy Minister is here, so let's have him respond to that particular issue.
Samson.
Atachan says that cannot be true.
Samson. The minister issued a statement.
Right.
And as you rightly pointed out in paragraph 12, it is stated clearly that on the 23rd March 2016, the Ghana Immigration Service started an investigation into the immigration status of the 3 accused persons and requested the BNI to hand them over for further investigation.
Right.
Then it goes on. They were therefore released on 24th March 2016 to the GIS as requested.
That's
Now,
not true.
Wait a minute. This is the statement released by the minister. Now, this is further corroborated by another release, press release, by the Immigration Service itself.
Okay, yeah.
And I have that press release here. 1, 2, paragraph 3.
Yes, they repeated this.
Yes,
Yeah.
it was repeated that the suspects were reportedly arrested by the BNI for engaging in acts suspected to be inimical to national security.
Yes.
So the initial arrest was effected by the BNI. Then the GIS on 23rd March 2016,
A day before they were taken to court.
yes, requested for their release to the service for the determination of their immigration status in the country. Then statements were extracted from them, etc. And so you see what the minister said was further corroborated by the Immigration Service.
It's cut and paste.
They-
There's
they-
no corroboration
they-
here, Leonard.
Okay,
they
so
are
so so,
clearly,
so just hold on for me. Let's hear him. No, I wanted him to stop interrupting you. Continue.
yes. So clearly there were 2 issues here. And so we ought to distinguish what the Immigration Service did from the charges that were preferred against the individuals. Remember, under the Immigration Act,
He's telling you that after the 24th, these individuals were not interviewed by the Immigration Service.
At all.
Tells you that they were actually not needed.
no. The Immigration Service had earlier
previous day.
interrogated them, yes,
Precisely.
in order to determine their status.
Right.
Yes.
Now, when they sent them to court, and the court ordered that bail be granted upon certain conditions, the Immigration Service had by then formed an opinion as to what step to take. Under the Immigration Act 2000, the Director of Immigration clearly is clothed with the power to repatriate a person who, in his opinion, has flouted Section 20 and 21 of that act. So he took steps by revoking their visas.
No,
which
before
were
you
issued.
get there, step by step, you're saying that after the court and the grant of bail, the Immigration Service, as alleged by these statements, needed these suspects
Yes.
for further interrogation.
Absolutely. Not further interrogation, but for further action.
For further action.
Yes.
I see. So you are suggesting that apart from the charges, the 3 charges of false declaration,
Yes.
did the Immigration Service need anything again about their status?
Of
their
course.
immigration status?
Yes. Yes.
What
you
is
see, the investigations the BNI did ought to be distinguished from the investigations the GIS did. I mean, if they were relying upon the same investigations, they wouldn't even have requested for the release of the same 3 individuals to the GIS for further investigations to be carried out. Remember that in matters that border on immigration issues, it is the clear mandate of the Ghana Immigration Service. It cannot be said
why
anywhere.
did the Immigration Service not take that decision and avoid putting the people before court with all the charges about
the
false
Immigration
declaration?
Service didn't put them before court. And that is the distinction that ought to be drawn.
No, the Immigration
The
Service.
Immigration Service never put them before court. All this while, they were in the custody of the BNI. The charges, they bringing the suspects to court and everything was at the instance of the BNI.
The
And so
charges,
those
the charges of
charges-
false declaration,
Yes.
pursuant to the Immigration Act,
Yes.
you are saying were done without recourse to the Immigration Service.
Even if it was done with recourse to the Immigration Service, it was only to the extent of extracting information from them on their status, on the possible declarations that were made and statements extracted not by the BNI, not by the GIS, but by the BNI.
Same information, the basis of which was, which grounded the repatriation.
Yes. Well, the BNI did their investigations, and remember that they did their investigations with a certain focus, which may be different from the Immigration Service.
Okay.
Their investigations largely centered on the security risks posed by the presence of those individuals in our jurisdiction.
What's your reaction? He's seeking to react on this.
I beg to differ, you see, because my very good friend and colleague is mixing up the issues. You see, there's no way the BNI could have formulated any serious charges on false declaration without the input of the Immigration Service. And we shouldn't run away from that fact. And from their statement, the Immigration Service had dealt with matters prior to the going to court. You understand? And if it was a matter of they having any serious arrangements to meet with them subsequent to they being admitted to bail, I'll pose this question. And Leonard, you should bear this in mind, having regard to the respect we should accord the justice delivery system. Is it not possible and feasible that people will enjoy limited freedom called bail and still report to authorities? Do you need to keep an individual behind bars in order to extract information or interrogate the person? You see, because that was a very serious, violation of the orders of the court, that you are saying that for one reason or the other, let me defy the order of the court. I will not surrender them to the registrar. I believe that there are outstanding issues coming from the Immigration Service which should be dealt with, and therefore I'll keep them and hand them over to the immigration. And if the truth be told, you have superintendence over them. There is no one interaction between the Immigration Service and the accusing.
But do you admit to the propriety of the charges of concealment of information against your clients?
Well, to be very honest, as defense counsel, I doubt the genuineness of the charges in relation to that. You see, because some people are confusing the fact that we will hold meetings to mean that probably there are engagements in Movenpick in which some individual...
The declaration they made,
yes,
for which they were granted the visas,
yes,
was to come and engage in business meetings, series of business meetings.
Sure.
Now, when they were interrogated, they now say, we have been engaged by the NPP to provide VIP security protection.
Yes.
Are these the same?
One dovetails into the other, because it is consistent with saying that I will hold business meetings by reason of my standing as a security consultant and dealing with the training programs. Because when you say business meetings and you think that training people is also not business meetings, you've placed a very limited understanding on business meetings.
Really?
Oh, sure. Oh, sure. What are you doing? His business is to train people. And when you should engage these civilians in the military training for the ultimate benefit of giving VIP security to Anakufuado, is very consistent with the business meetings.
Their main purpose for coming to the country is to conduct VIP security training for Nanado's security.
That is so.
And you say that is not different from declaring that they were coming to have business meetings.
Significantly. What is the difference? You see, because it is consistent with their expertise and what they stated as their background, that we are into security consultancy. So what happened in Ghana? Can't you see clearly that it is consistent with their profession and what they want to do? What is different about it?
I'm not cutting him short.
Just give me a little time. I want the two of them to.
You see, what I want my learned colleague to understand is that they came to this country on B1 visas, B1 business visa. Now, that category of visa does not entitle the holder to engage in any form of work or employment. What it simply means is that you hold meetings for business purposes, meetings.
This is specifically stated in which law?
What is a business? In this particular instance, they actually worked. They trained. The act of training 15 Ghanaians amounted to working.
Educators, which business visa allows you to work?
Clearly,
this is B1.
Yes, B1.
Yes. B what will allow you to work?
Samson, what I can tell you for a fact, and in law, per the regulations of the immigration services, that category of visa, the B1 business visa, did not entitle them to train people as
to work. Did not entitle them to
work.
Because
the act of training
they could engage
amounts
in
to
business meetings.
Business meetings
okay.
only.
Right.
And at particular locations.
No, we want for education of our listeners and viewers as well. Which business visa will allow you to work?
Yeah,
so that next time when I get a B1,
yes,
I know I'm not entitled to work.
Something, I mean, we can look at the immigration regulations. I have them here. The various categories of visas have clearly been spelled out.
Okay.
And all I can tell you is that the B1 business visa did not entitle them to do what they did.
Okay.
This is grounded in law.
So whilst I get other guys to speak to this matter, I'd like you to look for an educators, which
the category of
the category that allows you to work, if B1 does not allow you to work. Now, Mr. Tachin, is it not also curious to you that your clients would have the STL dossier, you know, seeking, as the statements say, to compromise, you know, the STL and the elections of this country?
Well, that was the most embarrassing statement I've ever heard. You see, because when you look at the charge sheets and the facts, and you were a lawyer of strong standing, look, that is a material fact that should be found in the charge sheet.
Fantastic.
Material. In fact, I'm tempted to believe that if that fact was stated and urged upon the judge, that it is not true that these individuals were just doing what they call military training, but they were interested in the elections of this country, which has serious ramifications. I'm tempted to believe that they will never have been admitted to bail. But conspicuously absent from the facts is this STL dimension. I am tempted to come to a conclusion that this is a post-facto rationalization. It is one of the kinds of red herring that the government needs to heighten unnecessary tensions and pressure, as if these individuals came here to come and give some electoral advantage to NPP. And let me tell you one funny thing, which is also so sad about this STL dimension. I have a lot of confidence in my senior, Mr. Ellis Osu-Forjo. Mr. Ellis Osu-Forjo was the one who was permitted to sit in the interrogations of the accused persons for 3 days. Some of them were running into over 4 hours. With the BNI, there was not one single line of investigation relating to STL. So please, if you believe that you have such a watery case against these individuals and you want to send them away,
James,
it is dangerous to invent stories after the people are out of the country.
Okay.
So this is a very false invention, and it's not good for us.
The aspect of one of them admitting to having the documents, the STL documents, is an invention of the BNI.
Samson, this is weird. And I am very shocked that my brother is arguing in this manner. Is he trying to say that right from the word go, from the time of arrest up till the time charges were slapped on them, Ellis Osu-Forjo sat through the investigations throughout the period? Is that what you want us to believe? You see, Samson, we must appreciate the fact that we are dealing with people who are professionals here. Look at the circumstances of the arrest of the 3 individuals and the false declarations they made, the attempt to conceal the true motives for entering our country. You see, when you do these things, you do not turn around and say that information extracted in the course of investigations were fabricated for the simple reason that the government wants to score cheap political points and heighten, anxiety and to make people think that the security of this country is about to be compromised by anybody. The behavior of the opposition MPP, those who brought in the individuals, Captain Koda, Captain Aqua, clearly demonstrates that something was wrong right from the outset. The investigations were done.
Paragraph 3 of the statement by the Interior Minister says that the 3 trainers revealed that, no, that's not what I want. Paragraph 4, a comprehensive report on the operations of Superlock Technologies Limited, STL, and an assessment of some key staff's vulnerability for possible compromise was retrieved from Haziz's room. STL is a company contracted by the Electoral Commission to transmit tallied election results. That's a whole debate we'll have later. 5 says Haziz denied authoring the document, but indicated that it was given to him by Danny Isaka, an Israeli based in South Africa. Haziz claimed he had not read the document, which had been in his possession for about 3 weeks. During interrogation, it was evident that he was conversant with the content of the documents.
Yes.
This, you say, is very serious.
Very serious
What was the suspicion? What did they want to do with STL or our elections?
Clearly, if you go by the outcome of the interrogation, the fact that Haziz even denied knowledge of the content of the document that was found in his possession, and his subsequent admissions that, look, it was a document handed over to him by one Danny Isaka, etc. And
granted that he knows the content.
Yes.
What is the fear?
Samson, the fear is that, why? Then somebody has the intention of interfering with the electoral process of this country and to undermine the integrity of same. And so you expected that, I mean, in the face of all these findings, the state security apparatus should have folded their hands and allowed those dangerous characters to continue to reside in our jurisdiction. The important thing we must all advert our minds to is that the Director of Immigration has the power to revoke the visa of a foreigner who enters our country, and the moment that revocation is done, immediately the person must be removed from the country. Yeah, notwithstanding the fact that certain court processes may have been initiated against the person.
His power in sections 20 and 21 is not contested.
So when a statutory function is discharged by a person in whom that statutory power is vested, I heard by a learned brother argue strenuously that the actions of government, the interior minister, and so on and so forth, was contemptuous and so on. How can you talk about contempt when the Director of Immigration merely discharged a statutory function?
Can you explain what you meant by that? That it was wrong for the directors to sort of overreach the court?
You see, the first thing I want to stress that if we're a law-respecting nation and we have 3 arms of government, then I do not want to say that even for convenience, logic, or whatever motive, anybody should defy the express orders of the court. But Samson, I want to crave your indulgence to see what the judge said. It will bring conclusion to these matters. Unless you are saying that, let's forget about the judiciary, they don't matter. You see, and I'm quoting the certified proceedings attaching. My lord, usually when they are granted bail, they take them back to the police custody or wherever. We are ready, the sureties, to stand and bail and pray for an order to take them to execute the bail conditions at the registry. By court. So pretend no guy is here. I'm sure he will ensure that the accused persons are taken to the registry for the bail conditions to be executed. They should be taken to the registry. And also for their passport to be deposited at the registry of the court. Case adjourned to the 12th of April 2016. So if my colleague here, who is also a lawyer, is saying that the Minister of Interior, the BNI boss, or even the President of Ghana can rubbish the express orders of the court by saying now, look, go to hell. We are not taking them to the registrar of the court. We will take them to where we want to take them. After all, there is another agency of government that is in need of them. We will surrender them to them, which has turned out to be patently false. It's not true.
We have moved on from that one.
So therefore,
we are now at the point of the repatriation and your problems with it. That it is also sort of an attempt to overreach the court somehow. How do you explain?
No, I never said.
That's also contemptuous.
I never said. I'm saying that the contempt is grounded on the fact that the BNI boss and the operatives defied the express orders of the court.
As far as the bail is concerned.
As far as the bail is concerned. Now, I will not say one word about the fact that they have been repatriated. You see, because the repatriation is insulting to them in the sense that now here is Ghana, the mirror of Africa's democracy, having put together a charge against individuals. I heard my very good friend Kofi Adams saying that these individuals were mercenaries trying to train potential terrorists. Oh, goodness me. God has blessed this country. Mercenaries have walked into your fold, and then you charge them in a court of competent jurisdiction and you let them off. I do not see how any serious security apparatus will go that low. But that is what I keep saying, that I believe that this whole melodrama was political. To tag Akufo-Addo as a man with violent propensities, one. Number two, to help, you see, to feed the NDC propaganda machinery with raw data and material that let's tag him again. We are close to election. Because if that is not the aim, I'm telling you the truth, that the whole arrangement is bizarre, number one. Number two, it undermines the rule of law. Number three, our international image as a constitutional arranged democracy has been insulted.
Hold on there, and James, hold on. Now, just hold on, I'll come to you. You just put down what you're thinking so that you don't forget. Now, Yao. No, hold on. Yao. See, yes. On the point of the immigration, deciding that we need to repatriate them, revoking their visas and everything else, the prosecution is the state's decision.
Yes.
They have taken somebody to court. They've decided later, that we are not interested. That's it. Ends the matter, isn't it?
Not exactly. Good morning. And now, if you may permit me, I'll just make a quick reference to a case that is usually at my disposal, Espati Afoda, Republic versus High Court Accra, Espati Afoda. And this is what the Supreme Court, speaking through Pega, said. As a matter of public policy, it is important that the authority of the court and the sanctity of his process and orders be maintained at all times. It is too dangerous to give to a litigant and his counsel the right to decide which orders or process of the court are lawful and therefore deserving of obedience, and if not, must be disobeyed. An order or process of a court of competent jurisdiction cannot be impeached by disobedience.
At all.
Now, and when this matter came up, I quickly looked at some drama which appeared to be repeating the Balogun case, which is well known. And this is one interesting quotation as well in the case, that the court will be to a great extent incapable of doing its duty to itself, as well as to Her Majesty's subjects, if it were to say that with perfectly accurate knowledge of the order of the court, a defendant is at liberty to defy the court's authority and then come to court and say, so. So I'm more concerned about...
And in the Balogun case, tell us briefly, in summary, what was it about?
Yes, when I was looking, and interesting, the next day, I saw, I think the venerable, what's his name? Cameron Dodu, saying that he said he sat in that court. And I think reported it.
Right.
I mean, this was an interesting drama. These people, and if you, on the side, J.B. Dankwa on one side, defending these people who obviously lean more towards the UP, because it took a political dimension. In the case where they wanted to deport these persons because, according to them, they were not Ghanaians and that they were engaging in acts that were conducive to disrupting the security of the nation and so on. And the charges were brought. Then, the Minister of Interior then, according to him, acting on the instructions of the Governor General at the time, and the minister happened to be our old man, Kobaduse, Minister of Interior at the time, now issued a deportation order and deported them. At the very time when the defendants, the plaintiffs or the applicants' lawyers were in court and had obtained an order of the court to restrain them. And according from the information, they had actually heard of the order having been made and yet ignored it. They said that the Governor General had a duty to perform under law. Similar expressions being made today. And therefore, they were duty-bound to act on it. And that is where the court really had strong words for them and even convicted them for contempt. And this is what the court said. In the case before me, it is not a question of disobedience to a court order, but it seems to me clear that with the knowledge which the first respondent possessed, that is the Minister for Interior, that a court order had been made and was virtually on the way there, that to serve him, there was an interference with the administration of law, an interference with the parties or litigants to give evidence during the litigation.
Okay.
Now, so when we look at what has happened, the court actually made orders, deposit the passport of these individuals with the registry of this court. Whether any other matter has arisen connected or not to this, it is an order of the court that had to be made. I believe if we have their passport, they may not have been able to travel, or we have the passport. So then also, in all this, I see some embarrassment that has been caused the Attorney General, and that will be caused the Attorney General on the day the case will be called, on the 12th, right?
Yes.
We are informed that on Thursday, the Attorney General filed a notice of withdrawal.
Yeah.
Nolli prosequi or
A notice of withdrawal, so the case is been withdrawn.
yes, but that is the embarrassment. It's also because I strongly believe that she was totally outside all this drama. She was not involved. So for her to now file whatever, if it's a withdrawal or virtually or effectively withdrawing the case or causing the case to be struck out of the course list of the court, it's an embarrassment.
It is.
You understand? And these are the sort of things that some of the ministries do, and we end up paying avoidable negotiated debt. I won't call it judgment debt because I don't have much problem with that.
Interesting.
So,
okay.
So on
yes.
Yes. So one.
James, I'll come to you, but I'll go to Kweku, and then when I come to you, I want you to remember the education I sought from you, the business visa that allows us to work, that allows a foreigner who is coming in to work.
One line. Yeah. So that, what is it? Have the parties now been informed that on the 12th the court is not going to hear the matter? They will still have to go to court. First of all, the court will inquire whether or not they have complied with the court orders. The court will have to inquire where are the accused persons to whom we granted bail. It is a clear disobedience, and I'm saying that to the extent that we never heard anything from the Attorney General, because the Attorney General commences and maintains all criminal proceedings. And when you do anything, as in the Ladan and the Balogun case and so on, that will appear to interfere with even the performance of the functions of the Attorney General, which was what was done even in 1958.
Interesting.
For me, it is a very serious matter. It is a breach of a constitutional provision.
Right. Okay. Kweku, we were here and we dealt with this aspect and how most of you felt that the BNI, had acted unlawfully and sought to disparage the court in the process by not following the orders. And now, as we know, they were taken away. How do you feel about that? And do you think that any wrong has been occasioned as a result of that? We say we put you in court, but we have taken the decision that we don't really need to try you. Just go away. We don't need you in this country.
I recall last week, some of us predicted that this was going to end nowhere. if you recall.
Yeah.
And that was especially because of the nature of the charges in court.
I remember you comparing it to the charges against Kenneth Japong and saying these are some of the things that happen and it doesn't get anywhere.
You know, it's worrying when it is the state that finds itself in this situation. The state and institutions and agencies of the state are mandated to investigate crime and to prosecute it if necessary. That's no dispute about that. Because individuals are out there who may be doing all sorts of things that threaten the stability or security of the state or other individuals. So we are all committed to that situation where the state and its agencies exercise their mandate to investigate and to prosecute. If in the course of that exercising of the mandate, the state itself breaches the law, I tell you, that's more serious than the perceived breach of the individual or a corporate entity that the state is supposed to be investigating. I shift the emphasis. Because otherwise, the state will lose its moral authority. If the state continues to violate the law whilst it is investigating alleged or perceived violations of law, the state then becomes the problem.
That is if you proceed on the premise that there was a violation.
But there was a violation of a court order
Well,
granting
they insist
bail.
that there was no violation.
Pathetic. They should tell that to the Marines. And I'm surprised that we have people who have the courage and the conviction to go out there and say that, no, there was no violation. I'm surprised. I'll be honest with you. I'm totally surprised, scandalized. And what I found funny is this attempt to suggest that the GIS came in later. But you see, when you read the charge sheet, as you said, from count 3 to count 5, it's all on immigration, violation of immigration laws. And then the brief facts that was presented, the last paragraph, if you like, says further investigations at Ghana Immigration Service. This BNI, the prosecutor, the investigator,
Right.
revealed that accused persons filled disembarkation forms indicating they were in Ghana to do business. So there had already been a certain level of collaboration between the BNI and the GIS, which resulted in the framing, the crafting of the account 3 to 5. In any case, assuming without admitting that indeed the GIS had further investigations to conduct, what was the barrier? You first fulfilled the bail conditions that had been granted by the court. And as Atasha said, I've also got a copy of the transcript. And I realized that he was being smart by alerting the court that, look, usually when you grant bails, these people are sent to the police custody and all sorts of things. So reminded the court, and the court said, look, send them to the registry. I've noticed a certain deliberate distortion by some media houses and government communicators that it was as if the court said, release them into the custody of the registry. And they were asking the funny question, does the registry have detention facilities? That's not what the court said. Process, it said take them there and get their bail things processed. It's the passports that were to be deposited. But some people deliberately create a distortion and then invite us to interrogate that distortion because it suits the kind of bogus defense that they are putting across. Hey, it's unusual. My brother is on.
Yes, please. But you are being heard. You are being heard. Because the microphone is. You have the microphone on you.
Look, let's be honest. Instinctively, I usually will give support to state institutions as the first step when there's supposed to be an allegation of a crime and investigation. I do that as an instinct. But beyond that, I do interrogation of the issues, particularly when you send a team into the realm of the courts. It helps all of us because then propaganda is excommunicated. Outside the court, please, outside the court, propaganda could could have some effect.
That's true.
Inside the court of no value. And I tell you, if we need time, you said this was not going to take much time, but the Minister of Interior statement, the profiling, the attempt to profile Koda, the attempt and to link it to a certain Serbian so-called intrusion here, that was an act, and somebody said I said act. A-R-T is what the minister had written. In civil insurrection, if it was of no national security consequences, it would not have been investigated in 2014. Then jailbreak is an attempt to profile. It was attempt by the minister.
Civil insurrection, that is treason.
Yes,
it's true.
Yes, it's treason. So it was being profiled to fit into the propaganda that had occurred outside the court. It's the same with the STL documentation. It's the same. That also is input there as a way of building a certain profile of subversion. And it is coming from the Minister of Interior.
Yes.
Because it was obvious now that in court, in the realm of the court, they had no case. But in order to keep the public mind still on that propaganda capital they sought to achieve earlier, now you have to go back and profile Koda, jailbreak, Koda, Serbian connection, and put it out there. So you keep the propaganda going. The case in court is lost. Now you've told us there's a notice of withdrawal. It ought not to have started in court at all. If there was any case, all the immigration had to use their immigration things and deal with the matter. But of course, if they had done that, who would have propaganda capital to use? There would be no propaganda ammunition out there. It would have been a simple, straightforward matter. But the truth is that there was a conscious attempt to create a certain environment. So we now had a situation where we're dealing with mercenaries and terrorists. That's what we're doing.
But could you also agree on the issue of concealment, that they concealed the reasons for which they were coming?
No, assuming without admitting that's true. And I said the false declaration. The thing is in that one they sent to court.
Yes.
And I'm saying that on that basis, if it's determined to be so, the immigration service could have dealt with the matter straightforward.
Do you think they should have indicated when they were coming and applying for the visas that they were coming to train VIP security, or they should have said they are coming for business meetings?
Well, I don't know.
That would have been a long
listen,
essay.
the DI man,
the
one who was invited by the DI. I have the kind of letter that was written to the Ghana embassy. Okay, this was dated 22nd December. Was written to the Ghana High Commission. Is it High Commission or Ghana Embassy? You know there's an extension.
Yeah, the mission.
It's a mission. And the guy was given a multiple visa. So he came. He was supposed to start the visit January 16th this year. So the first time he came, he hadn't come for any such business in terms of training. His visa is multiple. He entered this time in this business he was doing, this training, still on the DI request. Okay? If there's concealment there, and I'm saying that granted, the laws of the land provide the avenue for dealing with that matter. The laws do not give you the opportunity to first frame a weird, wild cat propaganda thing and put it out there. In the context of the fact that we had declared the general alert, okay, in this country, which we are all committed to.
The general terror alert.
The terror alert. It was within that context they played that game.
Okay.
And look, it's a dangerous game to play. At the end of the day, it can disarm all of us. In terms of the security consciousness that we have to build.
Okay, now let me move on here, but hold on briefly. Yao, we are told by the reports from the Interior Minister and the GIS that Captain Koda admitted that he erred, and that with the benefit of hindsight, he would have sought permission from the authorities. What in your mind is the
Koda has denied that. Don't ignore that.
What is in your mind, if that's true, what in your mind is that the permission that he was required to seek?
Well, if you read the police private security regulation, number one, all workers of a private security must be licensed, not just the institution alone, but the workers. So the question you ask is, these persons who were invited, and I will not personalize it. It's an institution of which Captain Koda also happened to be maybe a shareholder. So let's look at the institution that is licensed to perform the functions of a private security.
If they say he confessed that he agreed that he erred and that he should have sought permission, what kind of permission are we looking at?
Yeah, that's why I'm going into, probably, if it's true, then he's saying that he should have obtained license for those persons to work for that private security institution.
The 15 trainees, were they workers?
Yes, so that is where the question is. Even these people who came in, did they qualify to be employees?
No.
Or workers of that institution for which a license should be obtained? But if, on the hindsight, and he makes this so-called confession, has he not committed a criminal offense? Or hasn't the company, let me say so, committed a criminal offense for which officers of the company should be charged and processed before court?
No, according to the law, if the people are not taking through the process at the Interior Ministry to be vetted and to be licensed, as you say,
yes,
there are some fines to be paid.
Yes.
Yeah, it's not really, I'm not sure. There are some fines to be paid.
Yeah,
but
he should be on employees,
including a term of imprisonment.
Yes.
Okay.
Yeah, so what does erred mean here? If somebody erred and yet it doesn't amount to a criminal offense, then what is this business of portraying as if people have committed a criminal offense?
Okay.
But Samson,
yes.
should bear in mind that in the whole area of criminal jurisprudence, we are talking about the mental guilt, the mens rea. So if a man says that I owe it to my boss to provide VIP security, let me bring some individuals into Ghana to bring about that operation, where is the criminality? I'm looking at it. I'm looking at it from the perspective, where is the criminality here? Where is the mens rea? How would you say that people who are not subverting our constitutional dispensation, people who are not having hand grenades, people who are not using AK-47s and the rest of them are dangerous to the state? I told somebody in a joke that one of these days, I don't know whether Mr. Kwekubako does morning jogging. If we have locks on our shoulders and we are jogging around the 37 military hospital, they might say they want to survey the state. It is not every activity which has criminal implications. And I want to stress that if you want to train civilians to manage a crowd when a flag bearer is on the campaign trail or something like that, where is the criminality? So please, these laws are not intended to be quoted anyhow. The underlying factor is the criminality, and they are all absent.
By the regulation section, Regulation 11, Regulation 11 is to the effect that the following person shall not be granted a license or a permit under these regulations. And it lists a number of persons. And then it comes to Regulation 11(1)(d). A person in respect of whom the minister is satisfied that it is contrary to the national interest or the interest of national security, that person should be granted a license under these regulations. When the minister shall revoke the license or permit of that person who is convicted of an offense specified in, or the person will be sentenced to a period of imprisonment. I'm just trying to look at what the sanctions will be for.
Last week we dealt with this.
Yeah, we did.
Quickly.
Yes.
Look, my brother cited an authority, the Balogun case.
Yeah.
But this is an authority that should be distinguished. The facts and the law espoused in that case are completely different from the situation we find ourselves in relation
so that I don't forget, I asked for a certain education. I'm sure my listeners will be waiting for.
Let me take that up quickly. Yeah. The category of visa that the South Africans ought to have applied for in order to undertake the kind of activity they
or to work.
Yes, it's an H visa.
H visa.
Now, before such a visa is issued, one ought to apply for a work permit. So the application for the work permit must precede the issuance of the H visa. So if you obtain the work permit, the H visa is then issued. And so to start with, those individuals did not apply for a work permit in the first place.
But who tells you they were working?
But Samson, what is your definition of work? To come and bring together a group of people and train them.
And which of the regulations are you referring to, or the?
I'm referring to the immigration.
Immigration Act.
Regulations.
Regulations.
Yes,
Okay.
the regulations
Specifically, so I can see for myself as well.
They are there, but Samson, I can always
Okay.
give you the regulations. But let me.
So they needed an H visa.
An H visa. They needed a work permit.
And they needed a work permit.
Absolutely.
Okay.
And so to the extent that they applied for a B1 business visa, came in and undertook an activity which amounts to work. And I challenge anybody to come out and say
work
that
is not
the
business.
activity they undertook did not amount to working in our country.
No.
They were training people, that is work.
So there's a difference between business and work.
Absolutely.
No,
so they worked in this country without obtaining a work permit. The category of visa was not an H visa, it was a B1 business visa. So that is settled.
Okay.
But something. I would give you no. But please, I'm building a point. If I have to do that, you are trying. You derail me. So I will give you the regulations, Council. But let me make my point. I want to distinguish the authority you cited. The Balogun case is not applicable in these circumstances. Why is it so? Balogun, clearly, the Interior Minister was at the center of the deportation when he knew, Krobwe knew, that Balogun and others had actually applied to the court for a declaration that they were citizens of Ghana, not liable to deportation. So, armed with full knowledge, Krobwe instructed Majite, the commissioner of police at the time, to deport them. So clearly, he was caught. He knew that, yes, some processes had been initiated, they were pending. To stop the deportation. At the core of that suit was the citizenship of Balogun and others. But in this instant case, you see, we are dealing with a case whereby foreigners, South Africans, entered our country. First of all, they made false declarations and entered this country to undertake certain activities. Samson, I'm coming.
That is your view.
Now they trained people who are supposed to be the security detail of Akufo-Addo. They made false declarations. They were arrested by the BNI and charges slapped on them, including unlawful training and the false declarations they made. Now, the point is this. All this while, who was at the center of these charges?
I don't understand.
It was not, wait. It was not the minister. Neither was it the director BNI. Sorry, the director immigration. Now, at some point, the director immigration then stepped in. Even after a court had said, I have admitted them to bail on the basis of the charges preferred. The director immigration, acting in accordance with a statute, the Immigration Act 2000 under Section 21. And let me read Section 21.
The BNI
please.
I'm
distinguishing, I'm in the process. Why are you trying to truncate my argument midway? Let me land. Something. Section 21 of the Immigration Act 2000 reads, where the presence of a person in Ghana is unlawful, that person may be repatriated from Ghana by an order of the director. 2, where a person is ordered to be removed from Ghana under this act, that person may be arrested and detained for such period as may be necessary for making arrangements for his removal. A person may, for the purpose of subsection 1, be detained in any police station or immigration detention area. Samson, this is the law. Now, I'm saying that even in the face of the bail application and its grant by the court, etc., the immigration director, who is a separate entity, invoked this law.
Yes.
He invoked. I'm coming.
Respect
Can I land?
Court or not?
Can I
Answer
land?
that first before we proceed.
The point is that the director of immigration exercised a power under Section 21, and it's very clear.
Okay, I guess
Once the permit to stay in this country had been revoked, after the revocation, you couldn't be talking about processing bail and depositing passports when
You
the
are
very
justifying
basis,
the contempt.
wait a minute,
You
when
are
the
justifying
very
the
basis for the
question.
presence of those three individuals in this
there's a
country
question that has
revoked.
been asked to you by Kweku.
He's trying
There's
to
a question that
whittle
has
down
been
my-
asked to you by Kweku, and also Atachi had hinted on that question.
Yes.
Your statement that you issued
Yes.
had allegations of serious crimes,
Yes.
particularly against Captain Koda. Well, there were some references that obviously showed that some of the South Africans were dangerous elements.
In fact, they had traveled several times to South Africa and partaking in mercenary activity in that country.
Correct.
You mean South Africa?
So,
or Iraq?
no.
No, from South Africa to Iraq.
Right. Now, the question that's being asked you, Atacha says,
Yes.
Ghana is an example. And you are so lucky that mercenaries bring themselves to you.
Yes.
Kweku is saying, you talk about Captain Koda,
Yes.
involved in treasonable acts,
Yes.
acts of insurrection, acts of subversion. And all you do is press charges against him and withdraw them. And then these South Africans, all you do is repatriate them. I mean, how do you explain that to your people? How can they feel secure that the national security is protecting them?
You see, Samson, the act of removal of those dangerous elements in itself is a way of safeguarding the security of the country.
We've not proven it that they are dangerous.
They have been removed. We are saying that they came into the country upon false declarations.
And that
they
is
came in, they
punishment?
concealed their motives, they undertook unlawful training, and we found them dangerous to our national security.
And that is the ultimate punishment
So
they
we
can
thought
suffer.
that they were undesirable elements who needed to be removed from our jurisdiction immediately. That in itself is a security measure.
The question Kweku asked in addition to that
Yes.
is why were all of these serious matters, why did they not appear in court? Why were these not in any documentations before the court?
You see, Samson, we have to accept the fact that we have a certain inherent weakness in our legislations, our penal legislations, relative to the kinds of activities these individuals came into this country and undertook. At the same time, per the judgment of the security agencies of this country, their actions were inimical to our national security interests.
But you
They were inimical
couldn't
because
find a good law to deal with them. That's what you're saying.
they were charged, but we're saying that basically those were misdemeanors.
Yes, but the serious ones you couldn't
and for
find.
us, we thought that the removal of those individuals from our jurisdiction.
No, hold on. If you have people who you say have been frequenting Iraq,
Yes.
and you have said that they've been going and training mercenaries and so on and so forth, and they have been associated with some suspicious acts of terror or so on and so forth, you agree to that? The terrorism,
Insurrection.
the Anti-Terrorism Act says
Fantastic.
when you suspect a person to have had any connections, with terrorists or acts of terrorism, is grounds for you to use that law to charge them. Couldn't we have used that to charge them and hold
Here
them?
we're talking about evidence, and you know that is the name of the game. You're a lawyer, Samson.
Oh.
And so, wait a minute. We did all our investigations. We came to the conclusion that these are very dangerous characters. But at the same time, for purposes of prosecution, you see, it may be difficult to sustain a charge against them merely on grounds of their having traveled to South Africa. But at the same time, on security grounds, you would conclude that, look, their presence in the country is undesirable.
Okay.
And I'm saying that the law gives us cover to do that.
Okay.
In black and white, why do you want us to gloss over the express wording in section 21 and do otherwise?
Okay.
That was our election,
should have
grounded
begun-
in
you
law.
should have stuck to
no,
that from
why?
That's what you should have done.
Why? The
from
fact
the
that we
beginning.
preferred charges against them. In any case, that is why the Attorney General has the power to enter another
You
prosecute.
generated needless
Withdraw
heating.
charges.
Okay.
But
okay.
let me talk about Captain Koda.
But if
Yes.
Let me talk about
Briefly,
Koda.
let him finish on that,
Let
and
me
let me
talk
come to
about
you.
Captain Koda because Kweku raised interesting issues about Captain
What do you
Koda.
intend to do with him?
The statement the minister issued. What is it that is mischievous about that statement? Is it not true that Captain Koda broke jail?
Irrelevant.
Is that not a truism?
Irrelevant.
It is relevant because it portrays the person's character. The same Captain
Somebody else
Koda.
did it and became president.
No, please. But here is a Captain Koda who is at the center.
A coup maker who became president.
We are talking about the Captain Koda who is at the center of the arrival of these three South Africans who undertook an activity which was to train 15 individuals for the alleged personal protection of Akufo-Addo.
Alleged?
You see, yes, alleged, because the MPP has the invisible forces at their party headquarters. What did it happen at the party headquarters? Were they able to maintain security in the premises of their headquarters? Are you familiar with these facts?
Are you familiar with these facts? And this is a statement by Nana Asante too. He says, these statements are false. Number one, Professor Bani's statement said, quote, as a young officer, Captain Koda had been involved in the AFRC regime. Following accusations of corruption, he was convicted together with a colleague and incarcerated in the Usher Fort prison.
Yes.
These are the facts,
Yes.
according to his lawyers.
Yes.
Fact, yes.
So the fact of incarceration is certain.
Wait, yes.
Nobody can deny that.
Hold on. Yes,
Okay.
Captain Edmond Koda was involved in the uprising of June 4, 1979, which brought the AFRC regime into power. He was a member of the pre-trial investigation team. He and other members of the team were accused of having embezzled funds and were tried twice on the same charges. I guess you know what that means in our democracy. It can't happen. Double jeopardy.
That was not
right.
democracy.
Tried twice on the same charges by the People's Court. On both occasions, Captain Koda was acquitted and discharged. Both occasions.
That's not very accurate.
He was, however, imprisoned in the Usher Fort prison. Indeed, the chairman of the AFRC, Jerry Rawlings, demanded their release in November 1979. A request which was refused by the Liman government. Captain Koda and his other colleagues eventually broke jail and sought political asylum in the United Kingdom. The Francois Commission, headed by Appeal Court Judge Justice Francois, was set up to investigate the jailbreak. At the hearing of the commission, squadron leader Dagbe, the president of the People's Court, admitted that Captain Koda had been acquitted and discharged at the trial on the charges of embezzlement. Captain Koda has never been convicted of corruption as being claimed by the Minister of Interior. Then he said, refer to the Francois Commission report, which is available at the Supreme Court Library. Perhaps it is equally unsurprising that a simple check of official records to confirm basic facts is also fraught with incompetence.
Samson, have you read the Francois Commission report?
No, I have not.
I think we should all endeavor to read that report. Absanti Bediotio's statement is supposed to be a counter statement to the minister's statement, right? Now, first of all, his narrative is not even entirely accurate. His argument that Captain Koda was never convicted is a palpable falsehood. He was convicted, and that is why he continued to serve that jail term and ended up breaking jail. You cannot.
This is in the Francois report.
You let us all read it.
No, I'm asking you. Is it
I am
there?
speaking on authority.
Is it there?
I'm saying that the
No,
narrative.
you are treating me. I want to read it,
Yes.
but I want you to say that just as Asante Bedieto is making reference to that record, you are also making to that record that we will find in that record that he was convicted.
No. The point I'm making is that the Francois Commission's report does not support his argument that Koda was never convicted. It's not true. That is why I asked you to endeavor to read the Francois Commission report.
I'll read and bring the information to our listeners the next time.
Let's do that.
Viewers,
Kweku was an actor.
Yes, Kweku, you were saying there was a point about that. You were saying there was a point about that was not inaccurate.
That's again the reflection of the controversy that surrounded a lot of the AFIC trial processes. This argument has gone on for a long time. If you look at, and I would not want to say what I know, I'll say that later. But this is the January 14th.
Yes. I want to quickly wrap up here. We take a break, return. We have other very important issues to deal with.
Yes, this is January 14th to 20th, 1980, of the Palaver. It used to be edited by Chris Asher, who ran into exile some time ago. The headline is, Okaikwe Koda not guilty of corruption charge, says Captain Henry Smith, subsequently Major Henry Smith. He was a liaison officer of the AFIC to the Foreign Ministry. He's a very good friend of mine too. Now let me read some portions for you. When the allegation of the corruption and things came up, the Burma camp became stormy, and there were agitations for the arrest of Koda, Okaikwe, and others. And people. And
this Henry Smith is our ambassador in the U.S.
No.
Okay.
That's his brother.
Okay, that's Joseph. Sorry.
Yes.
Yeah.
Yes.
General Smith.
No, that one is his cousin, Henry Smith,
okay.
UK. That's his brother, his
Okay.
senior brother.
Okay. Okay.
Meanwhile, that is some issues. I don't want to, you don't have time. But as a result, I'm quoting Smith, who granted this interview from London. He says, as a result of the pressure from the other ranks, the two officers, that's Okaikwe and Koda, were put on trial, but were acquitted and discharged by the People's Court. Captain Smith said the acquittal and discharge of the two officers merely served to arouse greater anger of the troops who threatened to execute them, that's Okaikwe and Koda. In order to save the two officers from being executed, they were placed in custody and later tried for the second time with sentences passed on them.
So they were convicted.
And then listen to Smith. He says,
double jeopardy.
Referring to the trial, Captain Smith noted that since the two officers had been tried, acquitted, and discharged, fresh charges could not be brought against them again, concluding, you can't charge an accused twice for the same offense. These were all part of the controversies. And indeed, when the jailbreak, before the jailbreak, Mr. Rawlings had gone to the special tribunal. I have excerpts of the Francois Commission here, in terms of the media report. Okay. Had gone to the special tribunal and insisted on the release of these two officers, including one or two other ranks. Yes, indeed, it led to a situation where the warrants covering them were torn. Even though before the Francois Commission, the prison director went and said, look, there were no warrants covering them. And it was a typical aspect of AFIC trial processes. Some people were sent to prison without committal warrants.
Okay.
But at the commission, after interrogation, it turned out that indeed warrants covered them, but the warrants were torn by Superintendent Al-Hassan at the instruction of Jerry Rawlings. This is all documented in the report, as well as in the media. So you see, there's a controversy, but we all know that in law, you can't try somebody twice for the same offense.
Basic, yeah.
But you see, that's AFIC then. It wasn't a constitutional civil regime. That was an uprising, an insurrectional regime. So these things took place. And it was done in order to keep the ranks.
Okay. The question really about that is that, so you say the South Africans, you couldn't find any better law to deal with them as a serious offense. How about these people? You have said all these things about them, engage in some insurrection, some subversive acts, breaking jail. So what's the government's intentions?
So clearly, and you know the same Captain Koda and the Serbians. So he's somebody who has the propensity to resort to
questing.
He had nothing to do with
because
the
of all of this propensity and whatever.
Yes.
What is the intention of the state?
Because
he's a danger, according to you, he's a danger to us.
Yes.
What is the intention of the state?
Police inquiry bill, both Captain Koda and Captain Aqua. They are still, investigations are still ongoing, including the consignment of what Kweku would prefer to describe as non-lethal weapons, because I have always argued that somebody must make the determination that weapons presented as non-lethal are indeed non-lethal before you can even bring them into the country.
Because,
that is in relation to
because they were used through the Delta, is it security or found in the premises?
No, those items were consigned to him, not an abattoir, but I'm saying that these are matters that are being investigated.
You are setting that they'll be prosecuted.
No, you cannot. You can jump the gun.
No, they have to.
We are not in a kangaroo state. Samson,
I think we should.
We are not in a kangaroo state. We would conclude with the investigations before, if we have credible evidence with which to proceed against them.
What you have put out there is not credible enough.
No.
You don't believe in what you have put out there.
I'm saying that they are on police inquiry bail, and the essence of police inquiry bail is to afford the security agencies the opportunity to further with their investigations.
What happened in 2014? What happened to the Serbian connection? You are linking Kuda to it. What is the status of that? How was Kuda linked to the Serbian thing?
Kuda?
Yes. Because that's what the minister said.
Yes.
He said
his lawyers say he knows nothing about that.
Yeah, he's saying his name popped up as part of the investigation.
How?
Look, you want us to tell you
to put together
tell you
all right.
investigation.
Okay.
Can I have a minute on some serious matter?
Now we are running out of time. Yes,
just 1 second. You see, I was a bit surprised. Now, my colleague here was saying that if you are coming into Ghana and even you want to come and do a lecture, you need a work permit. I'm asking.
A lecture?
Yes, of course.
I can give you an example. I am the chairman of the Immigrant Quota Committee. Recently, professors from Belegon applied. I sit as chairman of that committee. They applied through us for immigrant quotas. Those are categories of work permits. You need that before you can undertake
when consultants come into the country to engage in lectures, like even experts. This gentleman from Nigeria came over here to talk about how the electoral systems were done. Were these people supposed to go for this H visa? Because they came here and they, in line with their training expertise, they were lecturing people.
In fact, when you go to the website, they indicate that it is the H1. When you go to the website, they indicate that it's the H1 visa that allows you to do some work.
Yes.
So you are saying that it's not correct?
It's not correct.
Okay.
It's totally false.
I can refer you to
my colleague said
relevant.
Sorry, he's not saying that what you are saying is not what is being used.
Yeah.
He's not saying what you are saying doesn't exist.
Yeah.
That's not what he said.
Okay.
So your reference.
He said that Captain Koda had been convicted, and that Nana Bediotio's statement was false. So why are you also now asking that when we asked you, you said that they are under investigation to be convicted again for the same offense? No. So let's even say that they have never been acquitted.
The aspect of
but you said that they have been convicted already. So if they've been convicted already, and from what you are saying, the same offenses are being investigated now, with the anticipation that they may be processed for court and go through criminal proceedings for the same offense.
For the aspect of the jailbreak.
Yes,
that's not what I meant.
That was brought in.
It is all part of
that is background information on Captain Koda.
Okay. Let me conclude.
All right. Sorry.
That's what you were doing.
Sorry. Let me read a few messages here and take a break. Bonti Benjamin says that the Interior Minister is doing more harm than good to the image of Ghana with contradictions and propaganda. Ghanaians deserve better, if not the best. Akwesi Champong says that what is becoming obvious daily in our politics is that most of the people appointed by the president to run the affairs of Ghana are trained propagandists. Whether these people have any expertise or work experience does not matter. Atai Moro in Wellency says, I am sure I am not the only one disappointed in the activities of the BNI. They act as if they are there to serve a political party and not the nation. Let's see what happens after 7th January next year. Musa Abatwa says, were there any violations in respect of the immigration laws of Ghana? Because on the statement issued by the immigration on paragraph 4, quote, they were training 15 Ghanaians in Accra on security drills which contradicted the express purpose for their coming to Ghana, which was to attend meetings, unquote. If indeed it is true, I think they acted lawfully. Their drills included weapon handling, and what has that got to do with crowd control? Ibrahim Kopa in Tamale says, there is absolutely nothing wrong about the coming of the 3 South African security consultants. The NDC is trying hard to score a non-existing political equalization goal vis-a-vis the Gitmo guys. Unfortunately, however, even if the NPP should bring in Satan into Ghana, impossible though, the NDC cannot use the 3 South Africans to wipe the sins of bringing the Gitmo into Ghana. Nana Akwesi Asafueje in Kwadase says, please, Honorable Agalga should know that the underlying principle in the Balogun case, which applies to this case here, is the willful violation of human dignity, which our present constitution frowns upon. The Rambo style, sounds like Wekubako, the Rambo style and violations of constitutional principles by the government, and which is being justified, is very excruciating. No amount of propaganda can stick on the personality of Captain Koda and by extension, Nana Akufo-Addo. Well, Nana Akufo-Addo has been compelled by some of these statements to restate that he's not known to be a violent person, and all his life, if he's fought any wars at all, he's fought them with his mouth. Thank you. We'll take a break. We'll be right back.
And his feet.
Alute.